So this is a 2-hour session. We are going to give brief overviews of a few different states from the East Coast. After this concludes, we will have a 15-minute break, and then we will have an intimate conversation between Laura DeCaro and Tim Segerblom, who is the Nevada State Senator who helped draft their regulatory structure, and that will be in the Moot courtroom. That's going to be from 6 to 6:45. And as you go into that room, there will be glasses of wine served. So it's going to be happy hour at 6, so the end is in sight. We have a wonderful panel lined up for you guys, so I'll let Jason take it away.
Thanks so much. Thank you all for joining us here on this afternoon, Friday afternoon. Already getting late, and we've got 2 hours of content still ahead of you. So we're going to try to keep it exciting. We're going to try to keep it moving. We're going to try to keep it fresh and engaging. I want to encourage you to raise your hands as we're going through and ask questions. Let me give you a little preview of what we have. We have a wonderful panel here talking about the Eastern Tigers. These are states east of the Mississippi that oftentimes get short shrift at conferences, and especially out west, where the focus is usually on, you know, Colorado and California, these big markets out west. The eastern United States has been developing its own regulations, its own programs, implementing different sorts of experiments on the state level in those laboratories in those states. So we want to give you some insights into how it works out east. And I'd like to start with just some introductions of our panelists and what states they're all going to be talking about. So before I even flip to the next slide, maybe, John, maybe you can start down on your end, just a brief introduction and your state.
Absolutely. My name is Jonathan Robbins. I'm an attorney based out of Fort Lauderdale, Florida. I work for a national law firm called Ackerman LLP, and I will be talking today about craziness and controversy going on in the state of Florida as we sit here. As I check my phone, frantically seeing if the application has come out today, because we keep getting promised it's any day now.
Hi everybody, I'm Dina Rollman, thrilled to be here. I am in-house counsel for GTI, which is a multi-state operator, but that began in Illinois. And I was with them from day one doing their application in Illinois. So I'm here to, 3 years later, talk about where we're at in Illinois.
Hi, I'm Katya Kosowski. I'm from Pennsylvania. Pennsylvania passed its medical marijuana laws last year, and they just issued permits to grower processors as one entity and dispensaries as separate site of entities about 2 weeks ago. So the process is just getting started.
Hi, I'm Jeff McCourt. I am a corporate and M&A attorney with Benish, based out of Cleveland, Ohio. I'm formerly practiced in Massachusetts, so I'm going to be talking about the Ohio market, which is right in the middle of licensure, and the emerging rec market in Massachusetts, which is coming along quickly.
I'm Karen Bernstein. I'm principal of Bernstein IP. It's my firm based out of New York. We're at our 10th year anniversary at the end of August. I'm going to be talking about New York, which is a very sad place. And also, I thought for just for fun to talk about Connecticut. Jersey we're skipping, so.
Hi, I'm Matthew Abel. I'm a senior partner at my firm, Cannabis Counsel, which has 5 lawyers in Detroit, Michigan. And Michigan's had medical for going on 9 years now, and we're just coming into a license process. So I'll speak about that.
And I'm Jason Klein. I'm based out of Washington, D.C., and I'm going to be talking about the District of Columbia and Maryland today. So we have, if you followed all that, we have 7 attorneys here. We have 10 different jurisdictions that we're going to be talking about, and we have 2 hours to fill, so that's going to be exciting. Rather than just giving everybody, 20 minutes and talking about their states, we're going to be taking a comparison and contrasting approach here. So what we've done is, here we've got a map here of the state, so you can see we're talking mostly about the northeast corridor and the Midwest. And of course, John's Florida is the outlier down there in the south.
Very lovely.
Okay, so we're going to be just sort of taking this comparing and contrasting approach on 6 different issues. We're going to be talking about pending and impactful litigation, qualifying conditions and patient registration barriers, licensing processes and future opportunities, definitions of ownership and control, testing and laboratory issues, and banking and financial. So this is not meant to be a comprehensive overview of every state. Really what we're trying to do is show you some of the different ways that each of our states has tackled these issues. We're going to jump right into it, and just to help keep track of what's going on here, we're going to be taking each of these issues one at a time, and we're going to be going through, and all 7 of us talking about our various states. All right, so we're going to just jump right into it here and talk about qualifying conditions and patient registration. I know panelists, the PowerPoint is now above your heads. So this is, and you can't see necessarily where we stand, but we're going to start with Connecticut and talking about the qualifying conditions and patient registration there.
We're going to talk about how exciting Connecticut is. It's certainly better than New York, I'll tell you this much. Connecticut is 18 plus in order to be a patient to get a card. There's a whole litany list of conditions, one of which doesn't include chronic pain. HIV positive, Parkinson's, MS, intractable spasticity, epilepsy, terminal illness, cerebral palsy. There is also, for minors, specific conditions. So that's pretty much Connecticut.
All right, so in the District of Columbia, it's a very unique approach to patient registration and how it works there. Most other states have a list of qualifying conditions that patients must go to a physician, and the physician registers them with the state by saying that the patient qualifies under one of these conditions and therefore can register for the program. In the District of Columbia, about 2 years ago, we passed a law that completely eliminated the qualifying conditions. The decision to become a patient is left up to the discretion of the doctor and the patient. If they collectively decide that the right course of treatment for the patient's condition is medical cannabis, then they can register them for the state program. I think it's an enlightened way to go. In theory, it should allow a lot more patients to register because you don't have to have some terribly intractable disease or condition be on your deathbed like some other places out east. Now, in practice, what really has happened is there are only about 5,500 patients currently registered in the District of Columbia. That's a low adoption rate. The District of Columbia has about 700,000 residents, so it's a very low number compared to most other states. Part of the reason that may be is because when you do register to become a patient in DC, you have to designate one dispensary that you will go to and use. You can't shop around and go to all the different dispensaries. And what that means is that it becomes a little bit less of a free market environment for you to operate in. On top of that, the District of Columbia has adult use recreational law on the books that we've passed. You may have heard that DC is one of these states that has an adult use law. It's called Ballot Initiative 71. We don't have retail programs set up, so we don't have dispensaries and cultivation centers for the retail use. But what we do have is a lot of patients that are out there growing their own or exchanging with each other, and so the dispensaries and the medical program is sort of a more expensive option. So we see relatively low patient registration numbers, well below 1% of the patients who are eligible. And on top of that, just one more note about DC. For any physician who registers more than 200 patients, they get audited by the DC Board of Medicine. And that's not a pleasant experience for a physician to go through. So there's sort of a disincentive to become a pot doc or to register a lot of patients because they have to go through this unpleasant experience. So we have a mix of incentives and disincentives in DC. I'm going to flip the page, and the next state is Florida and then Illinois.
So just a little bit of background. Back in 2014, the Florida legislature passed a high CBD, low THC law. They call it Charlotte's Web, but it was also called, the real name is the Compassionate Medical Cannabis Act of 2014. The reason that most people speculated was passed was in response to a constitutional ballot initiative that was on the books and up for consideration by the voters of the state of Florida back in 2014, which would have provided for a more open and robust system. So the legislature quickly passed a high CBD, low THC law, which was successful in that they were trying to defeat the constitutional amendment. In fact, they did, because Florida requires 60% supermajority for a constitutional amendment, and we missed by 2 points. So we were straddled for the last couple of years with a very, very restrictive program. Again, there were only very, very limited circumstances under which patients can be recommended to take marijuana that actually had THC in it, and that would be when you have less than a year to live. The sponsor of the constitutional amendment, Amendment 2, that passed in Florida in November, was a guy by the name of John Morgan, an Orlando attorney, a very sort of infamous, loud, in-your-face kind of guy. Very, very wealthy guy, and he bankrolled this thing with $10 million. And in November, in fact, the voters of Florida said by a majority of 71% that we do want a robust medical cannabis program in the state. And so that's what theoretically we're going to have. The qualifying debilitating medical conditions that would allow a patient to actually qualify to be able to take medical cannabis is cancer, epilepsy, glaucoma, HIV, AIDS, PTSD, ALS, Crohn's disease, Parkinson's, MS, and then the catch-all at the end, which I think is going to be the problem in the state, and which is going to cause a lot of litigation and a lot of regulatory proceedings, is, and I'll read the language to you just so I don't mess it up. Medical conditions of the same kind or class that a doctor believes or a physician believes the benefits outweigh the risks. So there was sort of a catch-all. And then when they came out with the legislation just a month ago, they did add chronic non-malignant pain related to those other conditions. So between the post-traumatic stress disorder and this now sort of catch-all, we have seen the patient population in Florida grow almost overnight from 3,000 to about 30,000 as we sit here today. The state spent a lot of time and effort to try to create a system where we wouldn't have. Florida has a history, as probably most of you know, of film mills. It's almost like we're the black eye in the United States, particularly for the cannabis industry. With the film mill issue, they really did not want a system where it was going to be like what they viewed California before Prop 64 to be, where you could go to Venice Beach and pretty much anybody's going to give you an ID card if you want one. Whether or not that's going to work is questionable, because I will tell you that there are now physician groups that are advertising, and they are doing exactly what the state didn't want them to do. But we'll talk about that more later, I guess, when we talk about the licensing process. You have to be a Florida resident without reciprocity, unless you're a snowbird who spends at least half the year there. And the requirements in terms of treatment, while they have been relaxed dramatically from the old 2014 law, where a patient had to be treated for 90 days before a physician could even recommend, which in many instances, with people I know personally, caused a real problem for people who had children suffering from epilepsy and other conditions where they had chronic seizures. So that's been relaxed. It should make it a bit easier, but the application process is just beginning now. The laws were just rolled out, and we don't have regs yet issued by the Department of Health.
So Illinois is almost 2 years into their medical program. When it started back, the first sales back in November of 2015, I think the state started with 3,000 patients, and a really bad feeling in everyone's stomach that this program might not be viable. The doctor certification form didn't have the catch-all. All it had was 40 qualifying conditions that were like, you have it or you don't, no sort of fudgy pain or things like that. And the doctors had to sign a certification saying that in their professional opinion, the benefits of use of medical cannabis outweighed the risks. That gave doctors a heart attack. They didn't study cannabis in medical school. They had absolutely no control over what the patient would then do at the dispensary, what they would be using, how they would dose it. So the doctors, by and large, just said no thanks and didn't participate. And that was sort of the situation for quite a while there. A few doctors were writing 95% of the prescriptions in the state, certifications in the state. There was no protection there saying, we're going to audit you. However, guess what? They did get audited. They had gotten charged. One of them got his ability to write certifications taken away from him through an administrative proceeding. So it's a really rocky rollout for Illinois. We have the governor who signed, ours is medical by statute. The governor who signed it into law was not reelected, and a Republican governor replaced him who's anti-medical cannabis, had said he never would have passed this law, never would have signed it into law, and he sat on the licenses before giving them out. It wasn't unclear if the licenses would ever even be given out. Then he grudgingly handed them out. We started with 3,000 patients, and everyone sort of hung in there for a little while. And then miraculously, through compromise down in Springfield, Illinois, we did get an amendment passed to our law which added PTSD as a qualifying condition, which changed the doctor's certification form, and now doctors only have to just certify that you have the medical condition. Their professional judgment doesn't really have to enter into whether you're going to benefit from it or not. Our program was really unusual because it was a 4-year pilot program. And it took so long for the regs to get passed, for the applications to come out, for the licenses to be awarded. But by the time they issued the licenses in February of 2015, we were almost halfway through the program and nowhere near our first sale to a patient. So we have now had that program extended to July of 2020. So it's really a full year, 4-year shot at the program. Now we have seen our patient count go up to about 20,000 patients. And we are seeing a lot more physician participation. One of the biggest hurdles, though, to our patient population, which I don't think exists anywhere else, and was just part of this legislative compromise to get a bipartisan bill passed, was that in Illinois, if you want to be a medical cannabis patient, you have to get fingerprinted. And it's horrible. I mean, it's horrible on multiple levels. It makes patients feel like they're criminals. It's inconvenient. A lot of people feel like it's just like an invasion of privacy. It's expensive. For elderly patients, a lot of them, they can't even, the fingerprints don't work. Their fingers, the sort of prints have worn away over time, so it doesn't even work, and they get an error, and then they have to go back. The people who own fingerprinting companies in Illinois who are making money off of this, they don't even support this requirement. They think it's cruel, so you know it's bad. And yet, here we are with really no hope of getting rid of it until we have a new governor. So everyone's just sort of working through it and sort of hanging on. We have a governor who's, I think, equally unpopular as Trump right now, and so the hope is that with the next election, we have two new guys heading in. So we'll see. That's where Illinois stands right now.
All right, Massachusetts.
Okay, so I guess, I don't know if Ohio is separately allocated there, but I can run through both of them kind of simultaneously. So Massachusetts was adopted in 2012 for the medical side and has been known kind of as a dysfunctional program for the last 6 years that it's been operating. It started with, it has 8 qualifying conditions, but it does have, as John mentioned, for Florida, the catch-all provision for conditions that a doctor believes is a debilitating medical condition, which theoretically would have helped patient population and patient access, but didn't, mostly because the commercial distribution system rollout was so dysfunctional in Massachusetts that over a period of 4 years, you had less than, I think, 15 operating what they call RMDs, retail marijuana dispensaries in Massachusetts. That is all rapidly changing now in the last, I don't know, probably about a year or so, that the state has kicked it into high gear, knowing what was on the offing, that there was likely to be a recreational measure that's been rolled into place. And as the recreational law, which I'll talk about separately when we get into those topics, it went through its legislative process to have the final battle through the legislature of what was going to be in the provisions. They adopted a number of changes that had been proposed to the medical marijuana law that should improve patient access in the meantime under the medical regime until the full recreational model is rolled out, and that merges eventually with the medical marijuana law. One of the biggest changes, which I would say is a trend that's now happening throughout several of the Eastern Tiger states, is that due to low patient count, the people who are operating in these regimes are saying, let's let somebody other than doctors and the pill mill type of operations recommend medical marijuana. So nurse practitioners are becoming the next source to point to as potential people who could recommend medical marijuana for qualifying conditions. So I think Massachusetts is somewhere around 35,000 patients now, and that's been a rapid increase recently. It started, I think, less than 2 when the program first rolled out, with similar results as Illinois, with less than a handful of doctors recommending, and that's increasing with practitioners after this legislative solution being allowed to recommend. So Ohio, when John was talking about being the black sheep of medical marijuana, I think that Ohio made a pretty good swing at taking the title from Florida in that regard. In 2015, we had what people colloquially in the industry refer to as the Nick Lachey monopoly that was proposed for Ohio by a group that was sponsoring a ballot initiative for a constitutional amendment that would have been recreational and medical, and had 10 grow licenses that were written into the Constitution by parcel number that would only be allocated to those 10 sponsors of that legislation. That failed by 2/3, but the result was in the exit polling that the Ohio legislature saw the writing on the wall that would have passed had it not had that monopoly component to it. So that scared the shit out of our legislature. They got working in January 2016 to adopt what they thought would be a functional, passable system for the patient advocates that have been pushing for this law for a long time, and did so in less than 3 months, which is unbelievable speed for our legislature, and I imagine many others, to move to adopt a comprehensive piece of legislation. So the result of that process, I was involved in it, so several members of my firm were with, was a program where our legislature was looking at Illinois, was looking at Maryland, what was going on there, and trying to put together the most highly restrictive, regulate these businesses like their nuclear bunkers program, but then try to allow a little bit better patient access to have them be more functional. So we have 21 qualifying conditions, one of which is pain. We also have PTSD and CTE, concussion syndrome, which are in the more squishy category of subjective conditions that could potentially allow more patient access. We don't have the catch-all program or provision that John mentioned, but it's interesting when, Dina, you're talking about the risk-benefit analysis, because that's something that even before the program has been operational, we had that in the legislation, and we pointed that out as it was being adopted, that was copied over from the Illinois requirements, and we said that's a problem, nobody's going to want to recommend. They still adopted it, but now in this last budget approval this year, we got them to take that out before they even created the registration system. So hopefully that will result in Ohio being a much bigger patient population on day one of dispensaries open, which will be next September 2018.
All right, so Maryland, which is a program that is currently in the process, just on the verge of actually reaching the first patient sales here in the next probably about 2 months or so. into the beginning of the fall, we expect to have some product on the shelves. There's a couple of cultivation centers that have plants in the ground in Maryland, and in fact a couple of dispensaries that are fully licensed and open, although their shelves are empty. The patient registration and condition list in Maryland is pretty broad and includes a chronic pain provision. The patient registration portal has been open in Maryland since I think it was April 1st when it opened, and they provide some regular updates. That number of 6,500 patients is probably a little bit on the low end for the number of patients already registered in Maryland, so it's actually off to a pretty decent start comparatively. One really interesting issue that has come about with the registrations here in the very early stages in Maryland is this idea of reciprocity. The Maryland law says that out-of-state patients who are receiving treatment in Maryland may participate in the program. So, of course, if you are a resident of Maryland, you can go to a physician and get registered and participate in the program. However, the law also says if you are receiving treatment in Maryland and you're not a resident, you may also participate in the program. The interpretation of that rule so far from our regulators has been that it applies only to people who are in inpatient treatment in Maryland, so people who are, say, at Johns Hopkins University or long-term stay in a treatment facility in Maryland, and that is it's questionable whether that's going to hold, or we might have some pushback on that. So it's possible that in the future Maryland may become a state like Nevada that allows patients reciprocity from other states. Michigan and New York after that.
All right, so in Michigan, we've had medical marijuana since 2008. It started 2009. The first cards were issued 4/2009, believe it or not. And we now have, almost 9 years into it, about 250,000 patients. So we have a patient caregiver model currently where a caregiver can only provide the cannabis to the up to 5 patients for whom they're registered. We're moving into a regulated dispensary, growing, processing license system. Also, there will be secure transporters. The license applications will be available December 15th. We expect the first licenses likely will be issued around April 1st next year. So currently, Michigan has several conditions that automatically qualify: cancer, glaucoma, HIV, hepatitis C, ALS, Crohn's disease, agitation of Alzheimer's, and Neil patella. In addition to those conditions, there are other symptoms that qualify. Those are cachexia, which is wasting, severe and chronic pain, which is the largest condition category in Michigan, severe nausea, seizures, severe and persistent muscle spasms. And then in addition to that, there's a procedure to request to add new qualifying conditions. Our law firm 5 years ago or so FOIA'd all of the requests that had been filed. Someone had put out a form suggesting that other people file requests for new conditions. When we got the results of the FOIA back, there were over 100 requests for new conditions. We went through and categorized them. They were, insomnia was one of the greatest numbers. There were 20 or 30 applications for insomnia to be considered. There were also requests for different psychological and psychiatric conditions. So what we did is we followed up and filed we had to sue the state because there was a timeline that they were not abiding by. And so when we sued them, they finally convened the panel. They considered and, we also filed a request for them to consider and add insomnia. Where with insomnia, there are very few public safety issues. People are not going to be driving around if they're taking it before they're going to sleep. And so we had numerous requests for that, and the board turned that down. In addition, they've denied autism and Parkinson's disease as other conditions. The only new condition which they have approved in Michigan is post-traumatic stress. And all the conditions are determined by a physician. Any MD or DO can write a recommendation in Michigan, but only those physicians can do that. So we don't expect that we're going to have new qualifying conditions anytime soon. After we had filed those other petitions, the state imposed a whole slew of new requirements that when you file a request for a new condition, you need to attach the medical, all of the medical documentation to it. Like, what are they going to do if we're going to research all the medical documentation? And so they made the hurdle a little higher, but fact is they're not really considering them very seriously anyway. The Lieutenant Governor of Michigan, Cali, has a child with autism, and he's a very strong supporter of adding autism, and even that was denied. So there are no new conditions. But again, the largest category is severe and chronic pain, and there are, we don't see any stopping. The number of patients and caregivers continue to increase, and it will until we get legalization, which should be on the ballot in 2018.
Okay, New York, very sad story. I think it was set up to fail. Cuomo was horrible. It was enacted, the Compassionate Care Act was enacted in June 2014. Presently, the statistics are as follows. There are 1,123 practitioners, which they just added nurse practitioners to be able to prescribe. There are 24,555 patients, but when you look at the scheme of things, New York is a giant state with a population of 8.5 million people. So it's a really hard thing. They're starting some delivery services. There's no access to smokable flour. There's no edibles. So you're left with capsules, vapes, inhalers. That's about it. There's about 11 conditions, including but not limited to Parkinson's disease, MS, epilepsy, and Huntington's disease, and chronic pain was just added in March. So they want to be able to present it as if they can add more conditions, but it's just a very sad thing in the state. We'll talk more about licensing and the stupidity with that as well coming up soon.
It's not 9 million, it's 19 million.
Sorry, I said 8.5 million. Is it 19 million? Is that what it says?
Yeah, 8.5. Michigan has 10 million.
19 million.
8 million is New York City.
Yeah. So you've got 24,000 patients, 19 million people.
But do you think that the nurse practitioner and the pain changes will improve peer review at all on the program? Or
No. I think it's awful when you start hearing about what's going on with the licenses. You'll get a feel. I'm trying to make this exciting. So.
I wanted to keep everyone in suspense by not adding what Pennsylvania is doing. But in reality, it's done a lot since it passed. It was a bill that was passed through legislation. It passed in April of 2016. It became effective in May of 2016, at which point the Department of Health started to write regulations. And since then, they've issued a slew of regulations. They've issued applications. Statutorily, 25 grower/processor licenses are permitted and 50 dispensary licenses. And each of those dispensary licenses can have up to 3 locations. So that's 150 dispensaries throughout all of Pennsylvania. The Department of Health said, okay, we're going to issue applications, but only for about half of what's permitted. This is called phase 1. We'll submit to us the applications. They're quite lengthy. I think most applications were submitted with over 150 pages worth of information. Also very expensive. In order to get a grower processor permit, there was a minimum of $2 million required in capital, which $500,000 had to be in a bank, or I'm sorry, financial institution. For dispensaries, it was cheaper. It was $150,000, all of which had to be in a financial institution. And everyone who has any sort of stake in investment in the company, and given the fact that most of these companies are privately held, was considered any percentage interest ownership had to go through background criminal checks. So last month, about 2 weeks ago, they issued the permits for 12 grower processors, 8 of which, there's no residency requirement in Pennsylvania. So 8 of those actually have facilities outside of the state, and so this is another state that they were able to acquire in Pennsylvania. And the dispensaries, there were 27 permits issued with a total of 52 locations that are going to open up. They now have 6 months to become operational, and that means that they need to comply with everything within their business plans as far as security, as far as building out the facility, and everything in compliance with regulations. And then once they get the seal of approval from the Department of Health, the grower processors can then go out for 30 days wherever they go, acquire their seeds or their nature plants, and then cultivate and then process on site. As far as patients go, and physicians, so the physician applications just came out yesterday or the day before yesterday, and there were 17 serious medical conditions that are authorized by the statute as to what can be written for recommendations. Those include cancer, autism. I think Pennsylvania is one of the few states that permit autism. Post-traumatic stress disorders, and then the catch-all is chronic pain. So with those, they believe when the program is fully implemented that it would get about 100,000 to 200,000 patients signed up, but it will take some time because patients can't yet register. Patients must register, caregivers must register, physicians who are going to be writing recommendations must register. Everyone is required to register with the Department of Health. Only the Department of Health will have a database of that can be searchable. No advertising is permitted by those physicians. The bill actually came to pass due to grassroots movements by parents of children that were suffering mostly from epileptic seizures and other ailments. And they were very persistent in going over to Harrisburg and talking to legislators and Governor Tom Wolf, and they got this bill passed. And because the program is not yet fully implemented, since permits were just issued and cultivation has to happen, the processing has to happen, they also issued a safe harbor provision, which permits caregivers of minors who have one of the 17 ailments to go out of state to acquire medical marijuana and come back and administer it to their children. How it's working, I don't really know, but there's about 270 plus letters that were issued as of 2 weeks ago. That number probably has grown since.
So, Katja, do you apply for that and they put your name on that says you're going to go out of state?
The safe harbor letters, as far as I know, those names are not released.
I wonder if they fly in.
But they do have to apply for a safe harbor letter from the Department of Health, and then the Department of Health.
Wow.
I wonder if they fly in. That's federal.
I don't know.
So you're
I don't know.
trained.
I don't, it's not one of those
Sessions
things that I.
meets him at the border.
Actually, we have the same thing in Ohio. We call the affirmative defense, but we don't have to register. So basically, if you can find a doctor that's willing to recommend before the state rolls out the medical enrollment process for doctors, you can do that. So there are people that basically, this is a boon for Michigan, because went to Detroit dispensaries now where people are driving up there.
I don't know anything about it yet.
So maybe the Pennsylvania folks are just taking the same route?
It is quite possible. I mean, I don't know what they're doing.
None of us do know.
The doctors who would be certified under the program are actually required to be physicians who actually provide current medical oversight over those 17 medical conditions, or one of those 17 medical conditions. So it's not any physician that can go and get certified. It has to be a physician that actually treats one of these conditions on a regular basis. And they're then required, once they register with the Department of Health, they're required to sit through a 4-hour course that will be designed by the Department of Health to give them information so that they can be better informed as to what it is that should be administered and how. If those physicians are registered with the Department of Health in order to issue recommendations, they're precluded from becoming investors in any sort of medical marijuana organizations. If a physician chooses to invest in a medical marijuana organization, then he's precluded from certifying and writing a certification for a recommendation for anyone. And then there's some more restrictions on those doctors that are certified. They can't write certifications for any of their family members or themselves. So it's pretty well regulated in that sense. And then within each dispensary, there's required to be someone, either a physician or a pharmacist in the primary location. And then the secondary locations for each of those licensees can then have a physician, a nurse, or a pharmacist assistant on site. If the doctor's recommendation is blank as to dosage or type of medical marijuana to be administered, then the patient, once they get to the dispensary, is required to go and have a consultation with the physician or pharmacist or nurse on site in order to be able to figure out the best form of medicine. There is a 30-day maximum allotment for medicine that can be purchased, so every 30 days a patient or a caregiver for a patient would have to go and obtain it. And a caregiver can be a caregiver for up to 5 patients. That would require the caregiver to, and a patient who is a minor can have up to 2 caregivers. So if it's a child, both parents do so. Minors are not permitted in any dispensaries unless they happen to be a patient or accompanied by a caregiver. There's a lot of information. I can just keep going on.
Well, I think this is a great place to start as far as this issue, the qualifying conditions issue, because it starts to give you a sense of how we regulate and do things out east, which is, for the most part, you know, a little different from how things go out west. And, you know, we regulate it very tightly, and everything is on the table. So this is a good place to start. It gives you a taste of what we do. The next issue that we're going to jump to now is some pending and impactful litigation that's going on in each of these states, because not all the states have litigation going on, but the ones that do, it can really have a big impact. So we're going to start at Connecticut and then move on to Florida.
So this isn't really impactful litigation. What it is the shakedown on the licensees. So the growers, for example, they had to pay, I mean, we're going to talk about this later, a lot of money, close to $3 million, somewhere around there, just to get in. But they're not taxed, so we'll talk about that later. But of those growers, they were fined anywhere from $500 to $300 grand in the last year or so for a number of mishaps, including selling cannabis before it was registered with state officials, admitting that pesticides or organic solvents were used during the manufacture of cannabis, plants grown for Connecticut dispensaries, mislabeling marijuana-infused cookies, and for failing to keep adequate business records. So, although they're harsh, what I gleaned from it was that the state was looking for even more revenue from a very tightly regulated state to begin with that was putting up so much money for these growers, and they will continue to shake it down. So that's the report from Connecticut. New York is more interesting. So.
We'll get there in a moment.
Wow, so what have we learned so far about the Eastern Tiger States? They're all dysfunctional. And the only thing I can say about Florida, the only positive thing I guess I can say is we're better than New York.
Well, I'm a PA in Colorado, so I'm fine by that.
In terms of pending and impactful litigation in Florida, most of it flows from the legislation that was just passed, signed into law by Governor Scott at the end of June. Senate and House legislature went to a regular session this year. There were 12 different bills that were floated, ranging from extremely liberal to beyond tight. The regular session ended, nothing got done. There was a special session, not called specifically for this purpose, but ultimately there was a Senate Bill 8A that was signed into law. The voters of Florida, as I said before, 71% of them said, we want this is our constitutional right, this is what we want. And so the Florida legislature basically ignored everything that these people said that they want. If you look at the constitutional amendment and the intent document that was promulgated to sort of talk about what was being meant by the amendment language, it's clear that vertical integration, for example, was not what was contemplated. It is clear that smoking medical cannabis was in fact contemplated, although not in public. The statute that was passed bans smoking, requires vertical integration. So there were 2 lawsuits that have been filed thus far since June 26th. One by John Morgan, who I mentioned before. He's the person who was responsible for getting the amendment passed. And John Morgan's lawsuit is about the smoking issue, and he made it clear that if a statute is enacted in Florida that bans smoking, I am going to sue the state over it, and in fact that's what he has done. The other lawsuit was filed by another Florida character by the name of Joe Redner. Joe is a guy who's been around Florida and has been the subject of much controversy for many, many years because he owns most of the strip clubs in Tampa. This guy was the creator of, or the self-proclaimed creator of the lap dance. And he's been arrested, I count, 111 times based upon various violations of ordinances and laws in the state relating to adult establishments and the like. Redner is suffering from stage 4 lung cancer. He is a vegan, and he is claiming that because we now have a constitutional right to consume medical cannabis, he should have the right to grow his own plants without pesticides. The language of the amendment makes clear that it is up to the Department of Health to regulate this and to promulgate the rules. So I'm not sure that constitutional claim is necessarily going to have teeth, but I am interested in seeing how it plays out. Characters. We've got to stay full of characters.
Great. All right, Illinois next.
So Illinois, when they awarded the licenses, there were a few sort of tiny little lawsuits that got resolved pretty quickly. So there were no litigation barriers to the program rolling out. Our litigation really has to do with these qualifying conditions. The way the statute was written, there's an administrative process for patients to file petitions to add qualifying conditions. And over the first year of the program, many petitions were filed. There was a statutorily created board to hear those petitions, and then they made a recommendation to the director of the Department of Public Health as to whether or not to add these conditions. And everything was sort of done procedurally by the book. The petitions were supported with medical literature. There was no opposition presented, and so 8 qualifying conditions, including chronic pain, were basically ready to be rubber stamped by the director of the Department of Public Health. And that sort of inexplicably he denied all of the petitions without any reasoning whatsoever. So lawsuits were filed challenging that, and it turned out what happened was the director of the Department of Public Health didn't put in any evidence to oppose adding those conditions. So the plaintiffs had said, the decision was against the manifest weight of the evidence to not add. And it turned out that in putting together the record, or in discovery, I guess, they found out that the director had, after the board ruled, outside of the public hearing and outside of the legislatively created process, had then done research to oppose adding these conditions and slipped it into the record that was given to the governor. So it's like just completely, but I don't know how many rules that violated of procedure and discovery and everything. So he got slammed very hard by the trial court judge, saying this was like an abomination that a governmental official would do this, and was ordered to add the conditions because there had been no evidence presented to counterbalance petitions. That became a political decision, basically, whether or not to appeal. And the hope was that they would realize they'd messed up and not appeal. Of course not, they appealed. And I believe the petitions were it was once again affirmed on appeal that the conditions should have been added, but it was remanded. And then in the meantime, our new governor basically tossed the entire board that had considered those original petitions. And as part of that amendment, where one giveth and one taketh away, he'd given us PTSD. He extended the program to 2020. We changed the doctor certification for him. Then the governor basically took away the right to add conditions. He gutted it. So we're in a situation now where this, the litigation is still going on, and it's going to be remanded to this kind of non-existent board, and it's essentially, I think, a hopeless situation. So a litigation to nowhere, I think.
All right, so Maryland, you may have heard about this. It's been making news. There's a lawsuit pending right now as we speak in Maryland involving the award of the growers' licenses. That award was made in August of 2016. So it's been about a year since they announced the businesses that were selected for the growers' licenses. There were 15 awarded for the state, and it was really no minority representation in that group. This is really interesting to note because the law that was passed in Maryland, the medical program, says that the commission, the Medical Cannabis Commission, needs to actively seek to achieve racial and ethnic diversity amongst the owners. So how could this come to be that we have a law that says they have to actively seek it, and then we have the award of the licenses where there basically is no diversity? During the development of the application and the regulations, the Maryland Attorney General's office weighed in on whether they could take race or ethnicity into account in scoring these applications. And basically, the opinion of the Attorney General's office in Maryland was that since this is a brand new program and there is no track record or history that the state couldn't consider race or ethnicity in awarding the applications. And the commission, rather than trying to commission its own study or do some more work or find some way around it, they basically just ignored that provision of the law entirely. And they went ahead with a blind scoring process. And lo and behold, there's really no or very, very little diversity. So one of the aggrieved applicants who didn't receive a license and is minority owned, called Alternative Medicine of Maryland, filed suit. This suit actually made a big splash in June when the trial court awarded a temporary restraining order on the issuance of any further licenses. That was in place for a couple of weeks, and then the Maryland Court of Appeals stepped in and said, we're going to take over from here. The TRO expired, and that case is moving forward in the Maryland Court of Appeals. There was just another hearing yesterday. It's anybody's guess to see where this goes. It could really, it could go all the way from, a nothing, where the state basically proved up its case that this was in compliance with the regulations and the law, or the aggrieved applicant could essentially blow up the entire program. And it's on the table that it's foreseeable that the state would need to go through an entire new application process. Given where we're at right now in Maryland, which is 15 growers who are in the process of building out facilities and investing on the order of $10 million per facility, and 100 or so dispensaries that are putting in $500,000 or $1 million to build out their own dispensaries. We're talking about maybe $250 million investment that's in the process of being made in Maryland. If the court were to throw out this first application process and demand a new one, that would cause a huge problem. So that has the potential to be extremely impactful.
There's a second litigation in Maryland too.
There's, sorry, would you like to talk about?
I mean, I'll mention.
Yeah.
I'm not over it, still going. My company GTI, we applied for cultivation license in Maryland. Licenses were to go to the top 15 scores. We got the 12th highest score. We should have received a license. The defendants took away our license and the 8th ranked applicant's license. They were willing to ignore racial diversity, but they did a post hoc geographic diversity adjustment, totally illegal. And so we've sued not to mess with the entire program itself. We were fine with the way the applications were in terms of the merits, but you know, if you're going to say the top 15 scores win, top 15 scores should win.
So the state scored all these 125 or so cultivation applications. They put them in order of, you know, the top 15 or 30, whatever they announced. Your company was amongst the top 15. They said they would be awarding the licenses to the top 15. And in the announcement they said, oh, but by the way, we are taking out 2 of them and putting in number 16 and 17 instead.
Numbers 20 and 21.
I'm sorry, 20 and 21
so it
instead.
wasn't 16, 17. It was, let's reach further down.
And this was, and the
20,
purpose
21.
of this was to geographically diversify the locations of the cultivation centers.
That would be an explanation given.
Yeah, interesting.
Could be other forces in play. But.
All right. So Massachusetts, Michigan, New York.
Yeah, so Massachusetts, mostly because of the dysfunction of rolling out the commercial distribution system, had a good amount of, I guess, relatively small litigation early on in the program over how licenses were awarded. They had this really complex process for applying for licenses that took forever, had many steps, one of which was getting kind of pre-approval from the state before you went and approached the municipalities, and then when people went to the municipalities and they said, oh God, no, don't do this here, and then created a lot of complicated discussions after that. The big one that everybody's talking about is the Barbudo case, the employment discrimination case, which I understand from the earlier panel that the attorney who was involved in that might be here. So if so, speak up and I'll let you chime in on that. But anyway, so that was a case that's the first that I know of that has said that, at least on a motion to dismiss, that for allowing a medical marijuana patient to use and providing an accommodation for that so that it's not on employment property or time, where they're doing it on their own outside of work hours, not showing up stoned, that's not per se unreasonable, so they sent the case back down to the trial court to have further hearings on. So that has really scared a lot of employers, especially in states that have ambiguity around the constitutional right to possess and use medical marijuana and non-discrimination provisions that might be in those laws. So for instance, like when I get on to talking about Ohio, we have a non-discrimination provision for medical marijuana that relates to things like public housing, but the employment lobby in the state was adamant about getting specific laws that would protect employers for this exact thing. So it's explicitly written in our legislation that employers have the ability to maintain in Ohio zero tolerance policies, where that wasn't the case in Massachusetts. So depending on what state you're in, you're really going to need to start looking at your policies to represent employers even if they have nothing to do with the cannabis industry, because it's going to be something that could be coming to your state rapidly. I personally think it's about time, and it's a good thing that this is developing, and I've been suggesting to my clients for a long time that they start thinking about whether a zero tolerance policy is good in practice for hiring and retaining qualified employees, or litigation reasons if you happen to be in one of these states. We're operating in multi-states, but this is potentially an issue.
Yeah. All right, New York, back to this fun place. So we're going to talk about licensing a little bit later, but just to give you a flavor, there were a number of applicants, how many I can't tell you, in New York for the for the license, and it's vertical, so, how many?
43.
Thank you. 43 licenses. So the top 5 were picked. Each license is 4 dispensaries. I feel like I'm being tested. Anyway, 5 of the licensees, and with these horrible statistics that I rattled off before, servicing, 24,555 patients, there's not a lot of money being made here. And so, lo and behold, the State Department of Health, the DOH, decided, you know what, we want to grant an additional 5 licenses. So what they did was they then said the next 5, top 5, would be the next ones that they would grant licenses to. And you can imagine how thrilled the first 5 licenses were. And oddly enough, 4 of the 5, I'm not going to name who didn't do it, but you can look it up, has now sued the Department of Health. And now this becomes a totally different issue, whether or not it's really enjoining the state from issuing the additional licenses. And what I find very odd is it's not easy to find the filings, which of course if I really went into Westlaw or Lexis and looked it up, I could. But that's as of May of 2017 when they filed it. So, you know, what is it? You're operating a dispensary that has limited amounts. They can only sell 5 products. And because it's vertical, 5 products, and of course no edibles and no flour, the 5 products are branded by that dispensary. So for example, Etain, whom I know the Peckham family really well, they have a lovely 5 products, 2 are inhalers, 1 is, I believe, capsules, and they can only brand their own presently, and I'll talk a little bit more about the licensing later, but it comes from their own grows. So, you know, this is a weird situation because you have a limited amount of people who are even working. They're not making any money, and some of them are bootstrapping their entire operation. So,
But they could just raise their prices, right?
no,
No, they can't. Why not?
because they have to get prices through the state.
Oh.
They get pre-approved for their pricing.
You're welcome.
So you've got controls on how much they can charge, to whom they can prescribe or sell to, and the amount of products that are available. It's a pretty sad story.
Michigan.
Okay, so in Michigan, there's been a little bit of litigation. We haven't gotten into the licensing phase yet, but I'm sure that'll generate some litigation. But currently, there are 4 items that I was going to mention. One, we have an affirmative defense. In Michigan, it's Section 8 of our law. The affirmative defense allows someone to defend a criminal case if a doctor recommended it, the quantity is no more than reasonably necessary to ensure the uninterrupted supply for themselves and their patients, and third, that it's for medical use. So early on in 2012, the Michigan Supreme Court ruled that patient-to-patient transfers were not allowed, caregiver-to-caregiver transfers were not allowed, and then that the only legal transfer is from a caregiver to one of that caregiver's patients. That's all under the card section, Section 4. However, there are people who believe that there's some room under Section 8, the affirmative defense. And in fact, in a recent Supreme Court case, the court ruled that, well, you might have, the Court of Appeals ruled you might have in Harsville. So you might have an affirmative defense if you're a caregiver or you're supplying some medicine to someone and you don't already have 5 patients. If you already have 5 patients, you're screwed. If you don't, though, you might be able to be a caregiver, an unregistered caregiver for these other patients. That's proceeding. I don't think that's going to go anywhere. I mean, it's a nice theory. It makes sense, but the court will say that's what it says, but that's not what it means, as they typically do. So I don't think that's going anywhere. Secondly, the Michigan State Police have been, their laboratory has been saying that if, for example, an oil or an extract which has no plant material in it, they cannot confirm that this came from marijuana plants, that it could be a synthetic, and so they're categorizing it as a synthetic. There's a lawyer in the state who's taken that suit and is suing the state police for clarification, or for, not for clarification, but to force them to stop doing that, to assume that this is synthetic when it might be or it might not be. So more interestingly, in the zoning area, we have a case called DeRuyter versus the Township of Byron, just outside of Grand Rapids. This township passed an ordinance saying that a caregiver must register, must be licensed at a certain location. Well, the medical marijuana law says that all other laws in contravention with it are superseded. And so the Kent County Circuit Court ruled that this township does not have the right to say that a caregiver must register. As long as that caregiver is in full compliance with all the rest of the Michigan law, the township cannot say, cannot add on additional requirements. That is now pending before the Court of Appeals, and I think that the Supremacy Clause will hold out, that it will last, and that eventually the legislature likely will change that Supremacy Clause. I don't see a way to get around that. Finally, there's an interesting case. Someone called me earlier this week where he has a distiller's license in northern Michigan. He has a craft distillery. He's also a caregiver and growing plants in a different building on the same property. So what happened was the Liquor Control Commission came in and said, you can't grow cannabis here, you can't be a caregiver here, and they're taking action, administrative action, against his distiller's license. He cares more about his distiller's license than he does about his medical marijuana card. However, the issue is, does the Liquor Control Commission, which is a state agency, have any right to tell him what he can do, similar to where a caregiver can grow or not grow under the DeRuyter case? Under this liquor control case, I think it's going to get really interesting because the LCC thinks that they have authority to regulate this. However, the medical marijuana law has a supremacy clause in it that is going to be in conflict with it. Again, that's why I think that the legislature eventually will change the supremacy clause. But that's the lay of the land for litigation as I know it in Michigan at this time.
Man's a litigious fellow. No, Michigan's a great place to watch litigation happen. There's a lot that happens in the courts in Michigan with regard to medical marijuana. So if you're looking for case law, Michigan's a good place to start. And Jeff, I know you touched a little bit on Ohio. So if you want to, if there's anything else to add there.
Not really anything new, I guess. So when you talk about Maryland and how that program kind of imploded on itself over the issue of diversity, Ohio, similar to Pennsylvania, was passing their state legislation about the same time as that issue started bubbling up, and so our legislators quite rightly wanted to do something to address diversity and inclusion in the program. In Pennsylvania, I think they probably took a better approach to do it in a constitutional manner, that it was done through the application process with encouragement, ranking points for a diversity plan.
It's actually the most important thing in the application rating.
And in Ohio, we have a statutory 15% set aside of every single category of license for minority-owned businesses that seems to me to be fairly clearly unconstitutional. So that's kind of just a big bullseye waiting for litigation at the end when they start allocating licenses. We'll see how it goes and how the Department of Commerce actually ends up allocating the license and where the point totals go and how that's factored in. But that's one of the spots that I would look to in Ohio for being an interesting development.
Got anything else to add?
Well, because the permits were just issued a couple of weeks ago, they had those that did not get awarded the permits had a 10-day appeal process, and I think some of them are starting to do that, and then we'll have to wait and see where it goes. But I think that part of the reason that the Department of Health only permitted about half of the number of statutorily allowed grower processors and dispensaries in the first phase is possibly because they thought we'll probably get sued by a bunch of applicants that don't get these permits, and so we'll then issue a phase 2, and there may be preferential treatment to those that were very close, or maybe not, or maybe it's just a second chance, and try to curtail that. But we'll have to wait and see.
Okay, so we're finishing up. That's our second issue that we've been through, and we've been at this for a little bit over an hour now. We have another 45 minutes to go. All right, so no one's actually got their head down on the desk yet, but we're going to try our hardest to get you there. 45 minutes. There's a lot of information too, and the slides are just meant to be, you know, scratching the surface. I want to encourage everybody to reach out and email or call, you know, your panelists if you have a question. Hey, what's going on in Connecticut? How's it working in that horrible state of New York? About anything at all, you know, we're happy to get you more information and answer all your questions. And so I just wanted to encourage you to do that, you know, after the conference is over. So we're going to talk about the licensing process in these states. And I think actually the licensing process is sort of one of the common grounds. Most or all of these states, except I think maybe not Michigan, have a competitive licensing process where there's a limited number of licenses that are given out, and the state regulators are in this position where they're deciding and evaluating who, you know, gets it, who gets the points, who scores the highest. And so we're going to talk about how all these states do it. We're going to start with John in Florida.
Sure. Let me try to pick up the pace here because I can talk for 2 hours about this. You guys don't want that. But everybody is watching Florida because of its population, because of it's Florida. Everybody's sort of looking at us. The first go around, the CBD law, there were to be 5 licenses awarded, 1 in each corner of the state, 1 in the middle. The requirements were beyond stringent, draconian, expensive. The fix was in my opinion. Having a relationship with the governor or his buddy at the Office of Compassionate Use certainly helped. So it resulted in many administrative challenges, which we brought. Under the legislation that just passed, there are 7 existing licensees now because of the administrative challenges. There will be more. They will be grandfathered in. There will be another 10 licenses given out, presumably, supposedly by October 3rd. And I would say that 5 of those 10 are already spoken for because essentially the first runners-up, the first go-around, are going to have the opportunity to get a medical marijuana treatment center license. That'll be the first 5. The 6th will go to a member of the Black Farmers Association because the way that the rule was written the last time, it really screwed minorities out of having the opportunity to apply because they have to have businesses in existence for 30 continuous years. So that's 6. 2 after that, this was snuck into the bill. Nobody even saw it coming, and I still don't get it. But the priority for the next 2 will be given to applicants who have citrus processing facilities.
No idea where that came from.
No idea. Ask Governor Scott. And so that really leaves, you know, you're talking about 3 or 4 licenses now, and I can tell you that based upon what I'm hearing, there are going to be well over 100 applications. Jason and I were talking before we started about whether we as attorneys could represent, when you have 3 or 4 spaces open, whether we have an ethical conflict representing multiple applicants, and that's probably the subject of another meeting. The applications are supposed to come out any day now. We're told they're going to be a little more streamlined. We're told that they're going to look more like Pennsylvania look, except that Florida requires vertical integration. So there will be 17 medical marijuana treatment centers. Each of those MMTCs will be allowed to open 25 storefronts. When the patient population hits 100,000 in Florida, there will be 4 more licenses given out. It is going to be an extremely, extremely competitive and expensive, beyond expensive process. You need to post a $5 million bond. The application fee, just the fee, non-refundable fee, was $62,000 the last round. I don't know what it will be this round. So it's going to be interesting. And I want to hopefully save some time for questions, so I'll pass it along.
Not much to say here. Illinois did its licensing process back in 2014, September 2014, to give out 21 cultivation licenses and 60 dispensary licenses. They were all given out. There are a few 2 years later, a few dispensaries that aren't operational, so they got their licenses yanked, but that's in litigation. So for all practical purposes, nothing on the horizon licensing-wise in Illinois.
So in Maryland, the application process all happened around the fall of 2015. There were a ton of applications that went in part because of relatively low barriers to entry for applications, unlike some other states with very high application fees and non-refundable fees like that. To submit an application for a dispensary in Maryland, for example, the fee was $1,000. You don't have to have the real estate under control, so you could submit multiple applications. We had, for the 15 growers licenses, I think there was about 125 applications that went in for those 15. For the processor licenses, approximately 15 of those, there was something like 160 of those applications. And for the 94 dispensary licenses, I think there was 897 applications. So, the scoring process was competitive. I talked a little bit about that elsewhere, and then that's done now, and these licenses are in the process of being handed out. There may be another opening of this process, the new application window in Maryland. Pretty unlikely at this point that would happen in 2017. Possible in 2018. But given all the other issues involving the rollout and litigation and things like that in Maryland, that's really not on the front burner right now. So we'll see where that goes. Massachusetts, Michigan, and New York.
So Massachusetts on the medical side has historically been a vertically integrated program, so the RMDs, retail marijuana dispensaries, had to be vertically integrated with the grow and processing facilities, which can be co-owned in a consortium of essentially 3 of those locations, which themselves can have an alternative location, so essentially 6 different facility locations by one ownership group was the limit, but historically Massachusetts required all of their businesses to be nonprofit entities. That was just changed in the REC legislation to finalize the Massachusetts REC program. So that has a process for the RMDs to convert over from nonprofits to for-profit businesses. On the REC side, a lot of it's to be determined. There's the kind of standard 4 categories of licenses that are outlined right now, and then how there's no requirements or prohibitions on vertical integration for the REC market. So it's kind of going to be up to the regulations how those ultimately get fleshed out. The one cool thing that's in the final bill on the REC side is something that they call a craft marijuana cultivation cooperative. That is somewhat loosely defined, but you'll have limitations on ownership, overall capacity and size. But that to me is, I'm always interested to see these little attempts to nod towards the history of the industry, and where Chris from Maine, what you guys have with your patient caregiver model, and Matt from Michigan, what happened in California, how you're trying to keep some of the craft and the small business side of the industry that is rapidly disappearing, and pretty much everything else east of the Mississippi, and moving over to more of the pharmaceutical, large business style model. These little initiatives are going to be interesting things to follow to see how successful that is to encourage participation by more people in the industry. I can go into Ohio. I was trying to go in order, but
Sorry.
We can, yeah, let's.
Oh, sure, yeah. So we're in the middle of the application process right now for licenses in Ohio. The grow applications were just submitted at the end of June. There were 24 total grows that were divided into 12 large, 12 small grows that started. So the large are 25,000 square feet. The small is 3,000, and each of those licenses, as patient count ramps up, can triple in size up to 75,000 square feet and 9,000 square feet for each of those licenses. The theory on the bifurcation of those two was to allocate some track of the licenses for people that wanted to have just like a craft flower business that we have in southeastern Ohio, Meigs County, around Athens, kind of our humbled people that have been the advocates and going off the grid for years. These licenses were kind of intended for them to have access to the market, so we'll see how that ends up going. The processing licenses, we have 40 total allocated and 60 total dispensaries allocated on that side. And those licenses are not due yet. We don't even have the applications out, but that should be any time within the next week or two.
I just wanted to put in my 2 cents. I'm sitting on an advisory board for one of the grower processor applicants, and they're also going to go through, well, there's the cultivator and then processor, right? And then dispensary. And I can tell you that I had to go through fingerprinting, background check. I had to go to NYPD headquarters and get fingerprinted. And any equity that I would receive would have to be limited because I'm an out-of-state resident. That sound about right to me?
So there's no residency restriction. What you're getting at is that there's a one grow limitation, so you can't have people who have financial interest in more than one grow. That's really the only restriction that Ohio has on horizontal integration at the grow level. Beyond that, you can have as many interests in processing and dispensary licensees as you want to. But the Department of Commerce went absolutely nuts on this financial interest thing, to the point where basically any licensing arrangements that you have, whatever, medicinals or Dixie Liquid coming in and providing you product, that you have to come up with a really creative way to structure your licensing thing so that you don't have to do fingerprints from every owner of Dixie Liquid.
Yeah, because it's crazy.
Medicinal. So they got a little out of control.
It was pretty crazy.
I spent a lot of billable hours coordinating fingerprinting for clients. Not anticipating the complexity of that.
All right, well in Michigan, December 15th, the applications will be available. That just happens to be a Friday. I think it'll be 4 o'clock when they put them online. There are 5 types of licenses. There are 3 types of growing licenses, A, B, and C, which are 500 plants, 1,000 plants, 1,500 plants. Those will be the only sizes of growing licenses under our system. Growing licenses can only be issued for real estate which is located either in industrial or agricultural areas. There's a lot more agricultural land than there is industrial in the state. Michigan is a huge agricultural state, and most people are looking in and around municipalities. I try to push them to go to the more rural areas where there's some townships have 300 people, and it might be a lot easier to convince them to do something in a small place than in a larger, more politically rambunctious area. So we have the growing licenses, processing, which will be for infused products, edibles, oils, topicals, beverages. The retail we're calling provisioning centers because they didn't want to call them dispensaries, so they had to find a name that hadn't been used anywhere else. And so they're calling them provisioning centers because we all need provision. There are testing labs. They're called the testing safety compliance facilities. Sorry, it just rolls off the tongue. So the testing labs are called safety compliance facilities, which are differentiated from production labs, which are making oils, etc. And then secure transporters. Our right-wing legislature was bullied by the tobacco and alcohol interests who are losing market share, and the police who want to be able. We already have included in the seed-to-sale tracking. But anything moved from a grow to a processor, or from a processor to a retailer, or from a grow directly to a retailer has to be moved by a secure transporter. Those will be separately licensed. The people who work and own those licenses cannot even have a medical marijuana card. So yeah, there's a group, there are 8 companies which are licensed to apply tobacco tax stamps to cigarettes, etc. in Michigan, and they've lobbied the legislature, and there's a bill pending that says that the only people who would get secure transporter licenses would be companies who have 8 years of experience collecting at least $5 million a year in excise taxes, so clearly it would be only those companies, and they would need the ability to transport it anywhere in the state within 48 hours or something like that. So we're really opposed to that, but that's we're gonna see how the devil in the details comes out about the transporters. So there is no number, no cap. There are no state caps on the number of licenses. The caps are left to the municipalities. In the city of Detroit, where I live, the city leaders have said we expect to have around 50 dispensaries when 2 years ago there were 250 dispensaries. They've been closing them, orange tagging them, bringing zoning violations, all kinds of things against those. There is a residency requirement for individuals. An individual who wishes to apply for a license must be a resident of Michigan for at least 2 years. However, there is no residency requirement apparently for any type of a business entity, so you can form an LLC tomorrow and file an application for a license. And by the way we drafted the legalization, which will be on the ballot in 2018, the only people who have first rights to apply for those for a year or two are the people that hold the medical marijuana facilities licenses. So those medical marijuana facilities licenses are going to be especially valuable when we move into the recreational. So there's also a 1% disclosure floor that any ownership at 1% or more needs to be disclosed. So apparently a 0.99% ownership would not be required to be disclosed. And if any of you lawyers know how our company, our law firm, could take a 0.99% cut of all of these, which the clients are approaching us saying, hey, instead of us paying you, how about we give you a cut? You know, and I'm like, hey, you know, philosophically, I really am on board with that. But practically, I'm not sure how that might work. Does that put me in conflict with other clients who we don't have a 0.99% share? And do we have to disclose that and all of that? So
2.94, can't be rounded as high.
2.94? Oh, 0.94?
2.94.
What about that other 0.5%?
Yeah.
0.05?
Give it to your son.
So we're all waiting for the rules to come out. The governor appointed the 5-member licensing board a couple of months ago. They met for the first time in a room that wasn't even large enough to hold everybody. When we were in, I was there on time, but I thought they were screening people to go in. And when we realized they were only letting people in as they let people out, and I yelled, let's storm the building. I think they started to let more people in at that point and have some standing room. So the board has scheduled to meet again on October 12th. The chair of the board, who's a retired legislator, indicated that in response to my comments and those of others that really you're only going to meet once between now and October. They said they will have at least one other meeting, but then the agenda came out the next day and it's still scheduled for October 12th. So on or about October 12th, we hope that there will be rules, administrative rules for these licenses. We still don't know what the applications are going to look like. The department has said that we should perhaps review what the gaming license applications look like in order to perhaps give our clients a little bit of a heads up about the type of criminal, business, and personal background checks that they're going to require. And so most of the municipalities, Michigan has over 1,700 municipalities, cities, townships, and villages. Each one of them can opt in. They don't have to opt out. It's an opt-in system. Unless they opt in, there will be no licensing. And people call us every day saying, where is this going to be? Where's the next city or town that's going to do it? We really have no idea. We're dealing with lots of municipalities. Yesterday, Kalamazoo, the city of Kalamazoo held public hearings. On Monday, I'm going to Kalamazoo Township, where they're holding public hearings. And so there's a lot of discussion going on, but when you talk to the people on the township boards, they generally say, we're waiting for the rules to come out. So when the rules come out, there's going to be an explosion of work. I'm telling everybody in my office, take your vacation now. So that's what I have to report from Michigan.
All right, so Connecticut, New York?
Yeah.
Very fast,
Go for it,
seriously.
please.
So the Department of Consumer Protection is the agency, DCP, that approves all applications for growers and dispensaries. There are 4 grow operations and 6 dispensaries. There are no more applications for producer licenses that are being accepted presently. As I referred to before, producers have to come up with this crap load of money to apply. First, they had to deposit $2 million in an escrow account just to qualify for consideration as an operation, plus a non-refundable $25,000 application fee. And if approved, then an additional $75,000 fee. And that tells you they want more money by getting all of these violations we talked about before. Physicians are barred from having a financial interest in any marijuana enterprise in Connecticut, and the producer must be certified by the state to sell products after testing. Dispensaries, pharmacists, a Connecticut licensed pharmacist can only apply, only a Connecticut licensed pharmacist can apply for a dispensary license. For dispensary operators, no Connecticut residency required. So it's quite interesting that the Connecticut has to be a licensed pharmacist in Connecticut, and it's only limited to pharmacists that can run dispensaries. I've already talked about New York. Just to sum it up, there are 5 licensees that are allowed to have 4 dispensaries, and there's no additional licenses available at this time.
Quickly about Pennsylvania.
Yes.
So I already talked about Pennsylvania licensing. The one thing I didn't say was that when they were issuing the grower processor, when they were issuing licenses, they divided up the state into 6 quadrants. And so each of those got 2 grower processors, and then the dispensaries were divided based on certain counties, based on the amount of population that the Department of Health established, had people in those counties that had one of the 17 serious medical conditions or a majority of those serious medical conditions, and that had easy access to transportation to get to a facility where it would be established. Separately, one thing that Pennsylvania is doing differently from most states is they're setting up clinical registrants to be able to do clinical research. So that has not yet come out with the applications as to what's going to be, but I think the applications are actually going to be very similar to what they have been right now for growers and for dispensaries. But in order to get access as a clinical researcher, they need to enter into an agreement with a medical school in order to do a specific type of research for a particular disease. And once they get that approved, then they do the applications to get a grower processor or a dispensary permit. I don't believe it can be within a hospital, but it could be near a location of a hospital. They can't administer them at hospitals. Doctors can administer it that way. And there's also a high barrier of entry. I think there's a minimum requirement of $15 million in order to be able to enter this.
Well, you have to have universities like Penn,
Yeah.
Jefferson Medical.
Jefferson is very much
Jefferson's
into it.
very into it.
I think UPMC maybe did
Yes, I
it,
have to say what I
but
think
I'm not
that's
really
right.
sure. It's kind of still, you know, these hospitals get all this federal funding, so they're a little bit skeptical.
But there
as to
was,
what they
I
can
believe
do.
also that the Kimmels, or one of the more wealthier families in Philly, is actually paying a lot of money for the research at Jeff.
Interestingly, I think someone from Australia gave me Jefferson in order to be able to do this.
I just know there's a lot of family money coming in.
So it is 5:25. We've been at it now for about an hour and a half. The next keynote session starts at 6, and we're supposed to finish up at 5:45. We are officially halfway through our presentation. Gosh,
We're
when
all
we did the dry run of this, we got through it in less than 3.5 hours, right? I mean, what I'd like to offer, and just sort of going to make an executive decision here, is just to sort of open it up to some questions. I haven't seen any hands going up. I'm not sure if there are. Wonderful. So let's take the next 20 minutes and just do some questions and talk about all these states. And please, Jeff.
So between the girls that are in this room, can y'all candidly tell us, are these, you know, you've limited number of licenses, are these chosen by political process? I mean, that's what I'm sort of getting, is that, you know, it's all, these are not being chosen by anything other than who knows whom.
I can't believe you would ask something.
I know. I wonder if there's anything other going on.
In this establishment?
I can tell you in Washington, D.C., which is not known for its politics, you know, I have no evidence. I can't show you evidence that proves my case up, but certainly the people who have the closest access to the politicians seem to be the ones who successfully received the licenses. So yeah, there seems to be a connection there. And there were some accusations, or there has been some accusations of that in Maryland as well. And I think, I mean, can we openly talk about some of that with some of these other states?
I'd like to just talk about something sidelining, which is, we talk about political. How about financially destructive? which is that one of the licenses holders in New York, the bank pulled out. They not only pulled out, and they were bootstrapped by their own family business. Her husband's owns a giant construction company. And not only did the bank pull all the funding for the dispensary and the grow operation, but all their personal accounts and the construction company that had over 80 employees. Now, if you tell me that could be an indication of political, some sort of sabotage, and they have not been able to basically recover from it. I think that her husband's business did, but as far as they're concerned, it's still cash only.
I would stand by Illinois' process, and there was a lot of skepticism. And during the application phase, I heard a ton of people saying, "Oh, our lobbyist told us we're going to get a license." It was just really funny. Like, you know, it was just such like open confidence in corruption. But then when you know, the music stopped and you saw who got the licenses, it didn't, to this day, I still don't think that that's what it was about. There were redacted applications and merit-based, and I would stand by it.
And I believe Pennsylvania tried really, really hard in order to keep as open of a process as they could with giving updates and saying where things were going, not releasing the names of anyone who was doing the scoring matrix, but saying that multiple people were doing those revisions, those reviews. And so I think that the intent is there. When I talked to legislators, they all said that the Department of Health was a black box, and no one could talk to anyone at the Department of Health while they were doing their scoring rubrics. And so I'm of the belief that they try to make it as fair as they could.
I don't know that I can say that about Florida. Not to sound overly pessimistic, but I will say that, first of all, there were certain requirements during the application process in Florida that seemed really arbitrary and seemed to favor certain applicants over others. And at the end of the day, well, two things. One is that those who ultimately were awarded licenses, and I'm talking about the 2014 process, you sort of knew who it was going to be, and it wasn't because they were necessarily the best. And then the administrative challenges did bear that out, because we had an administrative law judge in Tallahassee who effectively ruled that there were applicants who were really arbitrarily scored lower than others. And so that's one of the reasons we ended up with 2 more dispensing organizations. So while I'd like to believe that it's a fair and honest process, you're dealing with human beings, you're dealing with connections, you're dealing with money, you're dealing with lobbyists, and it has to have an impact.
So, I mean, I think everybody, the story largely on the East Coast is that this limitation on licenses creates massive market problems. And I think we can talk about whether we want to talk about political crony capitalism or not. Like, money is more important at the end of the day. I mean, money is what facilitates those connections. And I think that it has, basically corrupted the process and the industry on the East Coast. But there are like changes that are starting to come around in different states. And what I think is really interesting is what happened in Boston. In Massachusetts, around the introduction of the craft cultivator language. And I know other states are really looking at that. It's something that I've been working on for years, trying to get people adopted with Andrew Livingston at Vicente Cedarburg as well. And in fact, the senator that pressed that, we talked to him like several months or a month beforehand, and we've been talking to a lot of folks in Maryland as well. I mean, Maryland was fascinating. The staffer who was the one who did the bill called our MPP to figure out what went wrong, and they sent her over to us at Vicente Cedarburg, and she just was like, I can't figure out why no minorities got a license. Like, she was like fluxumed as to how the outcome was, and I'm like, it's crazy. It costs $3 million to just do the application. Like, what did you think was going to happen? And so it's interesting that there's this kind of obvious solution to address all of these things, like not letting the government pick winners and losers in a marketplace, and kind of reduce barriers to entry. And are there any, so I mean, my question essentially is anyone other than Massachusetts talking about kind of just simply reducing barriers to entry to the market with, I mean, it's not that complicated. So Massachusetts did something, and I know Maryland's looking at it, but hasn't done anything yet. Is anyone else even talking about it?
Yes. Maine
You're kind of like almost the West
The
Coast.
tiger of the East. Michigan will get there too. There's brothers in a lot of ways.
But there's like 100 people who live on Maine.
102 now. 1.4 million and 40 million tourists a year.
Yeah, there you go.
With reciprocity.
Yeah, Maine's legislative committee that's undergoing a review of the entire rec law that we voted into law last November is doing an excellent job in going through a lot of, issue by issue. And, among other things, there will be no capital requirements. The license fees will be under $1,000. There are no limitations on any of the license categories in terms of numbers of businesses. There will be caps on the cultivators and probably like a 4,000 plant cap for any given cultivator to start. There are a couple of economists that are on the committee and who are also legislators who have been excellent focusing exactly and using these words, barriers to entry, keeping those low. They're focused on the Cole memos, concentration, and I think you can sum up the Cole memo as prevent diversion as the central thread through most of the 8 guidelines. And they're taking that as we need to keep the price as low as possible. Now, they did just come out with sort of consensus that the tax will be between excise and sales 20%, which is higher than I wanted and than I thought they were going to go.
Lower than everyone else, though.
What's that? Yeah.
It's lower than every other state.
Right. And they're going to do significant sharing of that revenue with the municipalities through statute to incentivize municipalities to jump on board, because, as you know, in Colorado, that's been a problem with, I think it's still fewer than 50% of the municipalities in Colorado that actually allow any business licenses to exist in rec. But we'll see. There are a lot of conservative rural communities in Maine that are going to take, it's going to take a lot of education, but that's nice that it's just that.
I would, really quick, I'd look at the security regulations. The biggest, because if you map out the costs to building out a cannabis business,
right.
Your regulatory costs, you're looking at anywhere from $50,000 to $500,000 in a security system. And so it doesn't matter if you have low license fees. It doesn't matter.
It does, because that's a cost no matter what, no matter where you are.
Right, but you can
additional
lower your license fees all you want, and if you need a $500,000 security system, it doesn't matter, right? No poor person.
Sure.
So you have to be
it's
careful
across the
that
board.
mix.
With everything, they are. They are going to have reasonable security requirements, or security requirements, but they're not going to be unreasonable.
Awesome.
Andy's got a question. Yes, you do. Andy, you have a question?
Well, given that this is such a mess, and that by the time, let's say, a dispensary gets its license, it now has run out of all of its capital and needs to raise more capital or wants to sell, let's say that's assumption, can any of you talk about the transfer of these licenses in each of these states? Are you now a total new license application? Can you, and are there change of control provisions, 50%, 25%, can't transfer at all, comes up at the next renewal, anything like that? Might be premature for...
New York already, one of the licenses was taken over by a...
Right.
MedMen,
right?
Yes.
Yeah. So what are the limitations? Is it that they have to go through a whole new process, or?
I understand they just assume the license. I do not believe they have to go through a whole new process.
In Illinois, if it's above 49%, you need regulator approval.
Yep.
And they want to hold you to the plans of the previous license.
No, I think there was some approval in New York.
So your hands are tied. It's real, there's been a little bit of transferring, I think, within Illinois, but real quiet and takes forever. Not easy.
In Maryland, it's a 5%. Any 5% change of 5% ownership or more requires regulatory approval. But once the license is issued, you submit that intention to transfer a portion of your license or a portion of the ownership of the business that holds the license to regulators, and they have 45 days to respond, and if they don't respond in that time, it's presumed to be approved. Now that is contrasted against the District of Columbia, where best of luck trying to transfer your license. It's virtually impossible. And the Department of Health in the District of Columbia has only allowed it in one instance, where the owner, the holder of the license, was a husband and wife couple that had gone through a divorce. And basically the license was just going to sit there and not, you know, they weren't going to be able to do anything with it because of the divorce, and they did allow a transfer in that case. But that's a case-by-case thing, and we don't expect regulators to allow it.
Can you do 4% and then another 4%?
4.999.
But is it cumulative?
I mean, not cumulative.
So you could do 4% and then another 4% to the same people?
Well, to the same people, Mike.
Thank you.
Yeah. More questions, please.
Yeah, I'm curious. It seems that the states that have caps on the number of licenses, they've chosen different numbers, and they have different population bases. If it's a medical marijuana state, or different population sizes if it's a recreational marijuana state. I'm curious whether you think there's like a minimum scale for marijuana business, either a cultivator or a distributor. Is there a minimum customer base that they're going to need, or a minimum size that they need in order to compete? Because you could reduce or even eliminate all the barriers to entry, all the regulatory costs, and yet you still might get a state like New York with 5 companies that are growing inside. The market might just drive it to that. So I'm just curious whether or not there's a minimum scale for sort of your bread and butter operator that you see out there.
I would certainly think in New York, you better go to New York City. But you know, New York State is very big, and you have these large rural areas where people have very little access to these dispensaries. Indeed, one of the licenses that was up in, I believe they were in Albany, they just moved down to Manhattan because they weren't getting enough business. So I don't think you can do a market study. The reality is that if you're in a major metropolitan area like New York City, you're going to get more clientele than if you're in Buffalo. So it depends on the state. I think you can say the same thing for a big state like Pennsylvania or Florida. Because Pennsylvania is a big state too. They've got 5 states that they hit. And of course Florida is a giant state too. So you've got rural areas where people have no access and they have no way of transportation, which is why New York State, for example, is feigned allowing delivery. I don't even know what the restrictions are on that.
I think in part the answer to that question is, you know, sort of what the costs of running the business are, and how you can scale that up and take advantage of the larger scale. You know, most of these states allow big operations relative, you know, to a place like Michigan, for example, which is going to have 3 classes of grows, and the largest one being a 1,500 plant count limit, which by most standards is pretty small. So I think the question comes down to, well, what are the security requirements on a facility to open up? And if it's going to be a $500,000 security system that you need to have in place in order to hopefully have 1,500 plants running, well, then the bottom line is just going to be a lot more difficult to, you know, to square.
And not only that. But if you tax too much, it doesn't matter how big your cultivation is. If you're not going to take stuff off the black market, it doesn't matter.
No, that's a good point.
So it's really, it's what you guys are going through. It's all these regulations by state are changing. You can't tell economically. Every one of these states has a different scale, and every one of these states has a different way you'd have to slice and dice the financials of that grow or that dispensary to say it'll take this many patients to be profitable, or, you know, for that scale. So I think it's, unfortunately, the law is changing the economics.
And so much for free market in New York, where the state is dictating the dispensary how much to charge, and whether or not those citizens can even afford it.
Right, and to me that kind of, at least in the case of Ohio, this is less true of Massachusetts, but it reflects the political reality that Ohio is not a state that would have ever voluntarily gone into adopting a medical marijuana regime. So when they did it, and this is true of some of the other states around us, they wanted tightly regulated, well-capitalized businesses to where they're basically handing over essentially what will become likely some sort of pharmaceuticalized version of the cannabis. Like that's the track that this is headed in. So it's tough to envision a world where that model is like that model is going to coexist with kind of the craft and the patient caregiver model that exists in other states that largely revolves around the home grow market. Like so, for instance, like to your specific question, so Ohio has a nod for the grow side to have two different tracks of grows, like I mentioned, the 12 big, 12 small. I think it's going to be really tough for the small grows, the 3,000 square foot, to compete on a product basis if they're extracting for oil. If they're growing flower for oil, it's going to be tough to compete on a volume basis with the big grows. But if you have a creative business model and you're not sagged with the apparatus of the processing fees and the dispensary fees, and you're not trying to vertically integrate, there's probably a really good opportunity to have craft flower coming out of a 3,000 square foot grow. It's not tiny, and you could go up to a 9,000 square foot eventually if the patient count's there. So the potential's there, but these markets, most of the East Coast and Michigan, Maine being probably the biggest exceptions, are not really built to incentivize non-big businesses from what I can tell.
Yes.
I've been waiting to ask this question. Where's the money to be made as lawyers? Where's the bread and butter? I mean, it isn't in the licensing because there's just few licenses, right? So where do we make our money?
I'm going to sit down.
You know that 0.99%.
Yeah, in Florida, I think what we've seen is, like I touched upon earlier, we will represent one applicant in this round and one only. And it's not going to be a big money-making opportunity, but where we, and this perhaps might be because I'm at a big national firm as opposed to smaller regional firms where I think the money is going to be made in the branding and on the IP side. Ours are, larger corporate transactions, and I'm dealing with Florida and real estate transactions as well. And in Florida in particular, what's really interesting, crazy, is that you have these, they call them the cartel, these 7 families that have operated these nurseries for many, many years. They're a very low patient count in Florida. They're all hemorrhaging money. They're not making any money, but yet the valuations that are placed on these companies for equity transactions are $100 million. And so from the transactional side, I think there's certainly money to be made.
Investors, securities offerings.
Yeah.
The securities offerings, exactly.
The transactional work afterwards. I'm sorry, so I worked in cannabis on the West Coast, and there was a lot of transactional work. So once we all mature as an industry on the East Coast, all your leases, all your joint ventures, everything. M&A will be going on. There's a lot of money to be made for you guys on the transactional side.
Following up
And there will always be litigation. Litigation.
Yeah.
We'll come later.
Well, my name's Tracy Klein. I think we're just about at the end of this discussion. We have about 30 seconds, do we not, Mr. Klein?
I just want to encourage everybody to reach out to the panelists. There are so many different, states out there and different things happening. There's no way for anybody to track, everything all at once. So wherever you are, if you're interested in what's going on in Illinois or Massachusetts, Pennsylvania, Maryland, wherever it is, please reach out to us. We have a lot of other resources we can, things that we can send to you that we talked about today. And thanks so much for staying awake and entertaining. Thank you.